Yes, Sanjay, sir.
Thank you, Vijay Bhai, and very warm welcome and good morning to all of you. I welcome all of you on behalf of all the organizing association to this webinar, like Tax Friends Mumbai, Josh Professional Foundation, Income Tax Bar Association Varanasi, Income Tax Bar Association Prayagraj, Legal Relief Society Kolkata, and Bhiwandi Tax Practitioner Association Bhiwandi. Friends, this webinar is telecasted on Zoom also and YouTube also. Those members who are facing difficulty in joining on Zoom, they can join on YouTube also. And friends, one request to you, you can post your queries on Zoom and YouTube. We will address all the queries at the end of the webinar. Friends, I'll move further and I will resume our proceedings of today. Friends, I would take this opportunity to thank all the organizers for successful organization of 34 webinars till date within span of 2 months. It won't be fair on my part if I move further without recognizing efforts of the organizing team, a person who always preferred to be on backstage and away from the limelight, Vijay Keval Ramani sir, whose dedication and relentless efforts had successfully resulted in organization of 34 webinars within span of 2 months. Uh, the main reason, as per my opinion, the success of this webinar, the reason behind this success is a thoughtful selection of topics and equally brilliant selection of eminent speaker who justified the topics. Today is also not the exception. Today we have with us two stalwart personalities to address the to grace the occasion as a chairman of the session. We have with us R.P. Tolani sir, Vice President ITAT retired with us, and also we have a celebrity speaker, Advocate Rajiv Shankar Dwivedi, uh, advocate on record Supreme Court as a faculty in today's webinar. Friends, moving further, I'll like to give introduction of today's chairman of the session, Ramesh Tolani sir. Frankly speaking, it doesn't need any uh, introduction as is very much familiar and popular face in the legal fraternity. Friends, give me a moment. Mr. Tolani has successfully organized many two-day workshops on litigation skills development at Delhi, Ahmedabad, Nagpur at the request of IFA and ICAI. Though he doesn't need any introduction, as a formality, I'll run through his brief biodata. He's Mr. Ramesh P. Tolani, Vice President, Retired, Income Tax Appellate Tribunal, ITAT, Ministry of Law and Justice, Government of India, a law graduate from Nagpur University and LLM. Mr. Tolani now operates as a transfer pricing and international tax counsel and is engaged in tax and economic laws litigation before various judicial forums. Mr. Tolani was enrolled with Bar Council of Maharashtra in December 1980. He practiced law and matters relating to revenue, housing cooperative societies, educational institutions, company law, income tax, wealth tax, gift tax, estate duty, interest tax, super profit tax, sell tax, central sell tax in Maharashtra since 18 years. In 1998, Mr. Tolani was selected as a judicial member by the committee headed by Senior Judge, Supreme Court of India. He was promoted as a Vice President ITAT, Ahmedabad Zone, and superannuated in June 2017. During his tenure as a member, Mr. Tolani has posted at Hyderabad, Mumbai, Delhi, Jaipur, and Ahmedabad zonal vice president. In the long career of 20 years as a judicial member, vice president of ITAT, member of ITFE, Mr. R.P. Tolani has adjudicated on diverse provisions of domestic and international taxation, transfer pricing, and various other aspects of income tax, wealth tax, estate duty, and ancillary direct taxes in India. During his Delhi posting, Mr. Tolani was interested additional judicial work as a member of Appellate Tribunal for Foreign Exchange FEMA Tribunal. There are many judgments on important issues have been upheld by high courts and Supreme Court and are widely reported in leading tax magazines and journals. Friends, this was a quite biodata, very heavy biodata. I'll request all of you to join me in welcoming today's chairman of the session, Shri Tolani sir. Sir, you can take charge of the session. Thank you.
Good morning, everybody. I'm happy and delighted to see many stalwarts of the tax profession for whom I have immense sense of respect. And some of them I could not see, but I am here to interact with them. It's my good fortune to meet all the cream de la cream of the tax and other vocations. Now coming to the main topic, just to use the time more and more, today's topic, the importance of rules of interpretation in taxation and corporate laws is of much importance. Let me define the law. If the body is the legal provision, that is act, rules, regulations, notifications, then the soul of that body is always a correct interpretation. Unless you interpret the law correctly, the soul and body will not function. If the soul is dead, you know what the body does. And when body is dead, then soul has to leave it. So, all my professional brothers will agree that as a law student, as an advocate of law, as a judge of the judicial dispensation, the immense importance of rules of interpretation and construction are very necessary. The word construction is not added in the subject, but let me tell you, there is a difference between interpretation and construction. By interpreting word, we come to conclusion that is known as the art of construction. So now, coming to discuss the importance of rules of interpretation in the realm of corporate laws and taxation laws. Let me tell you, friends, maximum debates on industrial incentives and depreciation, manufacture process, we have dealt with so many of them, and many times crores of rupees of allowances were denied by the department, saying that this particular process doesn't amount to manufacture. These are all, subjects of interpretation. In tax provisions, you have the provisions to be interpreted. Then there are various entries in schedules, particularly in GST, in sales tax. They are to be interpreted. Because the laws are being enacted in a great hurry now, let me tell you, I am very unhappy at the way the various legislative bodies are enacting the laws in a hurry. And they are creating a sort of legal violence. They are on a sort of, legal warfare with the business community, and they want to pin them down economically and criminally on left, right, and center. This is not a good trend. Now, the more hurriedly enacted laws are promulgated, believe you me, that off and on you have to go for correct rules of interpretation, which courts take immense time. In fact, our judiciary is very loath to take a liberal view of the interpretation, and they always tend to go by a narrower meaning. Meaning thereby, you have to go to higher courts who take the, task and boldly interpret a word. Now, in my view, the learned speaker, Mr. Dwivedi, He will definitely take you through the analysis of the various rules of interpretation. But just to give a brief outline, the best rule of interpretation, which is uniformly accepted by all the courts, hands down, is literal rule of interpretation. Simply meaning every word should be given a literal meaning. But now we have two sets of interpretation. Statutory interpretation, that is the one defined provisions in the Act, the terminologies which are defined in the Act, rules, regulations, or notification. A. B. By way of explanation or by way of overriding provisions, what we call as non-obstant clause, notwithstanding, etc. But the maximum number time we are asked to interpret a provision is non-statutory rules of interpretation. They are literal interpretation, harmonious interpretation, regional interpretation, Haydn's rule or mischief rule, adjus generis, and if you remember the case of A. Sannyasi Law, in which a new way of interpreting the law, that is reading down of provisions. When in a law there are provisions which tend to come opposite to each other, then the court has a duty to work out a reading down of the provisions. So as the litigation increases, problems increase, courts are trying their best to interpret. I tell you a simple quotation. In Tamil Nadu, a case arose as to whether the coconut is a vegetable or not. It came in the Tamil Nadu sales tax. Why? Because in the schedule of exempt items, coconut was exempted from sales tax. So the traders claimed it as a vegetable. Department said, no, it is not a vegetable. Matter went right up to Supreme Court, which held that coconut, though a component of food as a vegetable, it is not a vegetable by itself. Likewise, it came in Bihar, whether sugarcane is vegetable or not, because there were so many sugar mills. So in everyday life, when you interpret various commodities, entries, likewise we have schedule in company law. I saw the schedule in FEMA Act. We have so many RBI regulations where terms are loosely worded. Now, if a term is strictly worded, you can deal with it. The problem is when the terminology is loosely worded. Now the issue arises, in case of a doubt, we should go for a dictionary meaning or we should go for a common parlance test, like say ginger, adrak. Now ginger was claimed to be a vegetable because even ginger is, I went to Gujarat where raw ginger is cooked as, turmeric is cooked as a vegetable. So off and on, we come across so many eventualities, so many disputes where we have to interpret the word. Now, what are the aspects of interpretation? A, the advocate. The advocate should know. Advocate means I include learned chartered accountants, company secretaries, because they are also eligible to argue in various forums. And everywhere the issue of interpretation becomes very important. And it can turn the table. So now, the point in issue is, when the words are loosely worded, and I'm telling you, in my experience of 20 years as an advocate and 20 years as a judge, judicial officer, I'm telling you, the violence which has been done with interpretation has damage the law more than anything else. A correct interpretation of law in practice and in procedure will always save you from the trouble. The issue came, if you remember, my chartered accountant brothers and taxation advocates, it came whether the audit report, submission of audit report, along with the return of income, or during the course of assessment proceedings, or during the course of appellate proceedings, whether it was a mandatory or a directory provision. Now, this was a clear subject of interpretation. Whether an obligation created by law on the subject taxpayer is directory or mandatory. Mandatory means which is unalienable. You have to do it. Any number of courts initially held that it is mandatory and the penalty was 1 lakh. Now, can you imagine? You go to a chartered accountant in good old days when it was introduced and 40 lakhs was the limit. The audit fee was 2,500 in small towns, maybe in Bombay 10,000 something. But if you don't submit it along with the return, even if you obtained it before the date of your filing the return, the penalty was 1 lakh. And many small traders were visited with this type of harsh penalty. What I mean to say is, all you professional brothers have a very deep obligation to apply correct rules of interpretation. And as soon as a law is passed, if there are loosely worded terminology, please take meetings, pass resolutions at forum level, Chamber of Commerce, and send it to the ministry that, sir, your legislation may be misinterpreted and the traders and the subjects have to run from pillar to post, go to unnecessary appeals, clogging the system and burdening themselves with financial issues and sometimes prosecution. I'm telling you, the way I see the temperament of the various governments, even at a drop of a hat, they want to prosecute you. And the fate of prosecution in criminal courts, my lawyer friends will agree, it is phenomenally disappointing. They take 10 years, 15 years. So what I mean to say, it is our duty. Everybody I see, most of you are very senior persons having 10 juniors, 20 juniors. It is our duty to emphasize the importance of understanding the correct rules of interpretation, examining the subject matter or issue or dispute or the list before you, and then adopting correct tools of interpretation and effectively putting it before the various adjudicatory forums, officers. I think this would suffice as a chairman for me to give you the sense of importance of this subject so that the learned speaker, Mr. Dwivedi, he will take you into the various aspects of the whole important aspect of interpretation. Just to tell you that recently our Honorable Harish Salve interpreted the Geneva Convention in the International Court of Justice and could save Mr. Kulbhushan Yadav from an imminent hanging. So much is the importance of law of interpretation. We must appreciate and we must try to imbibe it in our thinking and utilize it in our day-to-day practice and procedure. Thank you very much. I'm so honored to be among you, all the learned councils. Thank you very much and have a good time.
Thank you very much, Tolani sir, and it was a pleasure for all of us to hear from stalwart speaker and as senior as you, and you justified the role and in lucid manner with short and concise way you explained the importance of the topic. Friends, before moving further, I'll request all of you to post your queries on Zoom also and YouTube also. We will address all the queries at the end of the webinar. Now we will move further, and we know, I know that everyone is eager to hear today's distinguished speaker, Rajiv Shankar Dwivedi ji. I'll give a brief introduction of him for your kind pursuit. Friends, Rajiv Shankar Dwivedi, sir, is an advocate on record in Supreme Court of India. He is Group A panel lawyer for Union of India before the Supreme Court of India. He is Joint Secretary, Society of Construction Law, India. He has been admitted as a member of Chartered Institute of Arbitrators, CIR, 105-year-old worldwide organization based in London, UK. He is qualified tutor for training the arbitrators designated by CIR UK. He is also accredited as an arbitrator by CIARB UK and has been training arbitrators and arbitration practitioners. He is a member of Supreme Court Bar Association and advocate on record Association of the Supreme Court of India. He is also a member of Nani Palkiwala Arbitration Center, Chennai. He is co-chair of Real Estate Law Section, Indian National Bar Association. He is an executive committee member of Indian National Bar Association Public Policy Section. He has participated in Focus India, a seminar organized by Society of Construction Law, Singapore, held in Singapore in 2015. He participated in centenary function of ARB Singapore chapter held in Singapore in 2015. He has presented paper on Real Estate Regulatory Act in conference organized at Tashkent, Uzbekistan in June 2016, which was subsequently published in the prestigious Journal of All India Federation of Tax Practitioners Association. He has spoken in Society of Construction Law International Conference 2017 held at Delhi. He has given talk at Kochi Metro Railway Corporation, Kochi, AIFTP conference at Kolkata, etc. So, friends, his qualifications are very vast. I'll still take you through his biodata. He has done several matters before NCLT Delhi regarding mergers and acquisitions and case of insolvency bankruptcy code. He has successfully represented airlines like Jet, Sahara, Kings Airways, etc. in their dispute against the pilots on the issue pertaining to the pilot being workmen or not. He has represented railways. He has successfully represented in several electricity-related matters for organization in public sector and private sector like NHPC, SAIL, ACC, IEPL, etc. for arbitration and before CERC, APTEL and Supreme Court of India for tariff determination and also in cases on behalf of the beneficiaries and consumers. He has represented and appeared on several banks, Cement Corporation of India, Havels India Limited, Indian Railways, Goa State Infrastructure Development Corporation, HEC Ranchi, Ghaziabad Development Authority, Bihar Rajya Pul Nirman Nigam, Savai Madhavpur Central Cooperative Bank Limited, Bundi Central Cooperative Bank Limited, BSNL, MPCC, Kishanganj Medical College, NAFED, etc. He appears for several high courts of India, particularly Delhi, Bombay, Madras, Allahabad, Patna, Ranchi, etc. in relation to contractual toll-related cases, land acquisition cases, and other matters. He did LLB from Campus Law Center, Delhi University. He did his post-graduation in political science from Delhi University. He completed graduation with honors in political science from Ramjas College, Delhi University. He has been awarded Junior Research Fellowship by UGC in subject of public administration. He participated in a special program on PPP in infrastructure sector held at Indian Institute of Management, IIM Lucknow, Noida campus with Indian Railway Institute of Transport Management in 2009. Such a big biodata and as I said earlier, a right person for the right position, a very distinguished and eminent speaker. Friends, please join me in welcoming today's speaker, Rajiv Dwivedi, sir. Sir, you can take charge of the session now.
Rajiv ji, kindly unmute and connect your presentation.
Yes. Can you hear me?
Yes.
First of all, thanks a lot, Mr. Sanjay Nikam, for such a detailed introduction of mine. Actually, there's some issue with my internet today. That's why I have to get connected from two sources. So even if one gets disconnected, I will continue with my session. I'd like to thank Mr. R.P. Tolani, the Vice President of Income Tax Appellate Tribunal, Mr. Sanjay Nikam. I can also see Mr. Ganesh Purohit out there, Mr. Vijay, all the friends. The topic today about the interpretation of statute and the background of the topic which is given by Mr. Tolani in such a detailed manner and in such a beautiful manner that actually and truly justifies his 20 years as advocate and 20 years as a judge. Because as a lawyer, what a lawyer do, what a chartered accountant do, they actually interpret the provision. The interpretation which they provide is on the basis of the query or on the basis of the problem with which their clients have come to them. But when it comes to the other side of the bench, where Mr. Tolani had been for almost 20 years, there the interpretation has to be done as per the intention of the legislature, as per the words given, and it gives a vast, immense responsibility upon him to give the correct interpretation, which not only takes care of that particular one case at hand, but it actually lays down the interpretation to be followed by the other cases, other similar cases which are coming after that. So what actually is the interpretation? In fact, again, because Mr. Tolani had given so many wonderful food for thought, because if I just go by that, his speech, I think we can have a very long session on that only. Mr. Tolani had very correctly said that it is the body and soul of the law. The body of the law is the statute, and the soul of the law is the interpretation of the statute. How we interpret the particular statute, how the court interpret the particular statute to be followed by others, to be adopted by others, alone can instill a soul in that body. Because without the soul, the body is dead. That is why the responsibility, the role of interpretation is extremely high. We can gauge the significance of this role by the fact that this role has been given only to the judges. Nobody else has got this this capacity or this role of interpretation. In fact, actually, I'll be making my today's speech on the this PPT. That PPT has been shared on the screen. I will subsequently distribute the PPT also. But in fact, what has been provided to me by Mr. Tolani actually has tempted me to go much beyond the PPT. So first of all, if we see actually that what is the role of the professionals, what is the role of a lawyer or of a chartered accountant, who is a good lawyer, who is a bad lawyer, who is a good CA, it all boils down to the one term, that is interpretation. A good lawyer, a good CA is one who has the correct interpretation of the particular statute, who can apply the particular statute in a manner that suits the requirement of the client. Not only just apply that, who can get it confirmed from the court. And get it confirmed from the court, I mean to say that by his persuasion, by his arguments before the court, by the way he put how that this particular word needs to be interpreted in this very manner, and gives and provides sufficient material to support his contention. So the entire work of a professional, that being a lawyer, that being a CA, is actually of the interpretation only, is to provide their client with what is the correct interpretation, and how the problem that is being faced by the client can be resolved, can be faced by that interpretation. I will not be going in so much into the judgments, because the judgments are there for everybody to find out and see. There are very few judgments that I have used for my speech today. I will be defining, I will be explaining that what are the different principles of interpretation, what are those methods of interpretation, and I'll be going more into the technical part of the interpretation. How do we discipline our mind? How do we discipline ourselves so that we do the correct interpretation of the law, so that we can be more helpful for our clients, for our subject, for our work.
राजीव जी एक मिनट खाली इंटरप्रेट कर लो, आप इसका स्लाइड शो शुरू करिए ना खाली.
हाँ सर, अभी एक्चुअली सर that is why I said Mr. Tolani has given so much food for thought that I was just going through that, and they are all so very important and so very relevant part. So now, sir, coming to the interpretation. Interpretation is the art of finding out the true sense of an act enacted by giving.
सर खाली स्क्रीन पे F5 दबाइए, आपका स्लाइड शो चालू होगा. प्रेजेंटेशन दिख रही है बट स्लाइड शो नहीं करके वो नॉर्मल प्रेजेंटेशन.
Sir, I mean, this is how it has been done, sir. I am not very tech.
Just press F5. Just press F5.
F1.
F5.
F5. Okay, sir. I'll do that, sir. Okay. So, the duty of the legislature is to make the law. Now, having made the law, it is for the judiciary, it is for the court, it is for the officers of the court that and the professionals by way of lawyers and the chartered accountant to actually interpret that what the legislature actually intended to mean. And this process of deciphering the meaning of the word of the statute is interpretation. If we'll take the words of the great thinker Salmon, by interpreting or construction is by interpretation or construction is meant the process by which the court seeks to ascertain the meaning of the legislature through the medium of authoritative form in which it is expressed. In relation to a statute law, interpretation is of importance because the intention of the legislature can be deciphered only by the interpretation. So, the object of interpretation is that, number one, that whatever has been the idea of the legislature, the purpose of the legislature, that should be implemented in its totality. That is the object of the interpretation. Now, interpretation is an art of finding out what is the true sense of an enactment. There are several principles of interpretation. We'll come to those principles subsequently. Why the need of the principle? The need of the principle is that this interpretation must not be individual based. It cannot be that one person is interpreting a law in one manner, another in another manner. It cannot be a story of the 10 blind men and an elephant. It has to be a uniform. There should be a uniformity about it, and that uniformity provides a certainty. And that certainty is required for a just society, for an equal society. That the same law will be implemented for a weak person also, as well as for a strong person also. That is why several principles of interpretation have been created so as to ensure a uniform application of those principles in the case of the statutes. Now, the requirement of the interpretation is that the legislation in modern state is prompted by a policy to curb the public evil. Now, here I'd like to again to quote Mr. Tolani, and he has very rightly said that today the laws are being passed in a hurry. If we will look at the IBC code, Insolvency and Bankruptcy Code, the law came for the first time in the year 2016, and from then till now in 2020, it has undergone a massive change. One way can be as the law was being interpreted by the NCLAT or by the Supreme Court, and to meet the challenges posed by those interpretations, the government has been quick on its feet, and it has went on changing the law. But this also puts before us a very important question: the role and responsibility of the legislature, that they should provide a law which should be so fundamentally strong that it can take care and it can cater all the situations which are going to arise even in future. It can take care of the situation which are arising at present. If we will see the law of the earlier times, those are still valid, those are still subsisting. The laws which were made in 1840s, 1830s, our entire IBC, IPC, Code of Civil Procedure, Indian Penal Code, the General Clauses Act, all these laws were made somewhere in the 19th century, the Contract Act, and they have stood the test of the time. A law made in by taking everything in consideration, a well thought out law, stands a longer period of a time as compared to the law which are being made today. They are certainly made in a great hurry, but they are creating lot of problems of interpretation. They are creating lot of problems in implementation. So that is why the interpretation is required, and the modern legislature, in fact, some of the principle of interpretation, they itself require that what was the purpose for which the law was implemented. There are this principle of the mischief rule of interpretation, that what was the problem to take care of which the particular law had come into play. And the law should not be interpreted in a manner that it goes back to the same problems. It should provide a solution. The interpretation also discloses the intention of the legislature. Suppose the intention of the legislature is to bring more and more equality. The intention of the legislature is to take care of the centuries of discrimination or centuries of oppression. Then the interpretation of the law has to be in that very manner that it take those intentions forward. Another thing is that every word have more than one meaning, or there is a possibility that a particular sentence or a particular word is posing more than one meaning. So which particular meaning has to be taken? This is the role of the interpretation, which provides how that has to be done. Now, the exercise of interpretation, as I have said earlier, has to be uniform, just, non-arbitrary, and same for everybody. To ensure this, some set rules are important. It cannot be a word of mouth. Like if somebody is very strong enough and he says that, according to me, this is the interpretation, that cannot be such. As a judge of a Supreme Court, somebody say that I am the judge and I am saying that this is the interpretation, that cannot be allowed. So the interpretation has to be based upon certain principles. Those principles have to be uniform. Those principles have to be applicable and have to be adopted in each such similar situation. So if we say that the tools of interpretation will have to see that what are the purpose, object, we will see that in every enactment there are preamble, there are a statement of object and reasoning. So those are the things which provide us a tool. They are kind of a chisels for interpreting, for sharpening those laws. It is assumed that the legislature, while making a law, was aware of every aspect. Whatever word he has used, whatever comma, full stop, hyphen that he has used has a purpose. Nothing is superfluous, and the interpretation must take care of those aspects. The purpose and the process of the construction, and Mr. Tolani has very rightly said that interpretation and constructions are two different things. Interpretation is the process, construction is the tool. By way of construction, we actually interpret those methods. So the process of construction should be such that it makes the statute effective and workable. It should not make any provision of the statute redundant. It should not make that the interpretation should not make the particular statute as an something as absurd. So what are the things which need to be interpreted? They are mainly the statutes and the what are the, if we loosely use the word statute, then when we say statute, we basically mean it to be the constitution, that is the Constitution of India, the central acts, the state acts, the ordinances, the bylaws, rules, regulations, notifications, circulars, instructions, clarifications, directions. So these are the methods by which intention of the executive or the intention of the legislature are expressed, are implemented. This is what we call law. And for the implementation of these law, the role of interpretation comes, that how these law has to be implemented, what was meant by these words when they were expressed by the legislature or by the executive. Another basis of classification of the statute is one is the basis of duration. Some are perpetual statute, like if we say the Code of Civil Procedure, or if we say the Indian Penal Code, or if we say this the other statutory acts. So they are the law in perpetuity. Other are temporary statute. Those are the law which are implemented when some urgency kind of situations are arising. For example, at the moment when this COVID is going on, and we have seen that the Pandemic Eradication Act has been put into use. So these are the statutes which are there in the rule book, but they are implemented when the need such arises. Then another classification, and that is very significant, is the classification on the basis of the nature of operation. That is prospective effect, retrospective effect, directory, or mandatory. These four classifications are such which have occupied the time of the court, I think, to the maximum. For example, in the Arbitration Act, one amendment came in the year 2015. Before 2015, there was the rule that if there is an award in arbitration and the award is challenged, then merely by filing the challenge, the effect of the award was stayed. And the execution of the award will have to await the finalization of the challenge process or the decision on the challenge. That position was changed by the 2015 amendment. So the question arose that whether that amendment is prospective in nature or retrospective in nature. The matter went to the Supreme Court, and in the matter of, I think, Kochi, Kochi IPL team, or and there was a series of cases in which that matter was considered and decided. The principles were read that if it is a procedural law, then it will be a retrospective. If it is substantive law, it will be prospective. If it is a judgment of the court, it will be deemed to be retrospective, because that merely interprets a law, unless it is specified in the judgment that the impact of the interpretation in this judgment will be from this date onwards. Retrospective. So even now, just now, at the time of declaration of the COVID, one declaration was made by the court that the limit of the insolvency and to declare a company as a insolvent has been raised from 1 lakh to 1 crore. Now there is a lot of discussion going, and in fact, one order has come from Calcutta NCLT in this regard, that this is only a prospective amendment and it will not have any impact on the earlier matter or those matters which are pending. Therefore, these interpretations are given that how a particular amendment in the law has to be interpreted, how a notification has to be interpreted, that whether this particular notification is prospective or it is applicable from today, or it has to be given a retrospective effect. Another aspect is mandatory and directory, that where may would be read as shall or where shall would be read as may. Here I'll just show. May is called directory, shall is called mandatory. Wherever the word may is used, it means that you may do it, or if you are not doing it, there is no no implication or of not doing the same. But where it is the word shall is used, or where the intention of the legislature is to do something mandatorily, their non-doing of that particular act will actually nullify the whole work, the whole work or the whole act. So that is why it is very important to correctly interpret that it was a mandatory provision or it is a directory provision. Then there are another statutes. There are enabling statutes, disabling statutes, permissive, prohibitory, codifying statute. Enabling statutes are, I'll just run through them speedily. I'm sure all of you must be doing that, but still. Enabling statutes are, there are some statutes or some law which bring a kind of arrangement into force. So those are the enabling laws. Then there are certain disabling laws which put a stop on all the law which are already there in effect. Prohibitory statute which prohibit something to be some act, conduct some act of the persons. Permissive statute, they allow certain act to be done without commanding that they may be performed. Codifying statutes, suppose there are scattered law. On the same point, there are so many things, but the laws are in a very scattered manner. So assemble them in one place and give them a shape, a codified shape. The consolidating. So these are the different kind of statutes. Without going into their detail, we will further come. Now there are different aids of interpretation. They are mainly of two kinds: internal aid and external aid. The internal aid are like title, preamble, heading, marginal note. If you will see in a law, there is some marginal note in the bottom. Are those words superfluous? The answer is no. Those footnotes or those asterisks which lead to those footnotes, those marginal notes, those illustrations, they demonstrate the intention of the legislature. They demonstrate that what is the manner in which the legislature has intended those words to be interpreted. Suppose there is a title of the act. There are the title of the act actually demonstrate that what was in the mind of the legislature, what is the target group for which they intended to make this law. Then there is a preamble. The biggest example is the preamble of the Constitution of India, that we, the people of India, having solemnly resolved to constitute India into a sovereign, secular, socialist, democratic republic. So every interpretation of our constitution has to be within the confines and within the prescribed parameters of that preamble. Similarly, the particular heading of that very chapter. The heading of the chapter further clarify the area within which the sections or the wording of those particular sections have to be interpreted. So these are the internal aids which are being provided by the lawmaker. Lawmakers are also aware of the fact that the law that we are making will tomorrow be interpreted by the court. So the lawmaker provide the tools. They also provide that what was in their mind by way of leaving those tools in the statute. This explanation, definitions, the transitional provisions. The transitional provision here means that suppose there was some earlier provision of the laws in the same field, and when the new law has come, then how the change from the earlier to the new has to be done. So the method provided will also provide how the interpretation has to be done. Then there are some external aids. Now, external aids are the parliamentary material, speeches, historical background, law commission reports, the committee, official statements, some earlier judgments, the dictionary meaning, foreign decisions. So these are the external aids which are being used by the lawyers or the judges. As I have stated earlier, that the interpretation, the correct implementation of the rule of interpretation is what actually ensures justice. The court is not expected to interpret arbitrarily. Therefore, there have to be a certain uniformity. And that is where the concept of justice is actually accepted and felt. If the interpretation is the same interpretation is applied on everybody, irrespective of who is standing in front of the judge, that the people get the sense of justice. That yes, law has not only been done, it has been seen to have been done. And that is why it is extremely important to understand the rules of interpretation and to imbibe them in our daily conduct, in our interaction with the court, in our profession. As Mr. Tolani had just said, that the most important rule of interpretation is the rule of literal interpretation. So when I am saying a mango, the first interpretation should be that of a mango only. It should not be that of something guava or something else. So the literal interpretation is the first rule of interpretation. Every interpretation has to be done the way it is. If the words are capable of an ordinary interpretation, then just stop there. Nothing more is to be interpreted into that. Nothing more is to be read into that, and nothing more is to be derived from that or deducted from that. So, to have the literal interpretation, the most important thing is that the word should be capable of only one interpretation. The phrase should be capable of only one interpretation. If it is capable of more than one interpretation, then the strict rule of interpretation or the literal interpretation, it cannot work. The entire problem arises when we deviate from the first rule of literal interpretation. And then the individual biases or the individual perceptions they start creeping into it. It is a different matter that the law of interpretation provide to the method to discipline those biases or a method to prohibit those biases. But a literal interpretation is the golden rule, and which says that no other method, no other biases can be read into it or put into it. So as I have said, that the literal meaning are subject to the following condition, that the statute may itself provide a special meaning for the term. We will see that in every law, especially either section 2 mostly, or sometimes even section 3, it provides the interpretation. So for the purpose of that particular law, what the legislature meant. So if the interpretation is giving of every word that is used in that particular statute, then that alone has to be used. The technical words are given ordinary in, I think my one computer has got it. Anyway, are you, can you hear me, sir?
Yes, yes, sir. Please continue.
Okay. Now the technical words are to be given the ordinary technical meaning.
राजीव जी, सिर्फ एक छोटी सी रिक्वेस्ट करता हूँ, आप
सर,
ये इसमें देखेंगे ना, नीचे स्लाइड करके दिखेगा राइट साइड में नीचे.
ओके सर.
एरो है ना माइनस के बाजू में, देखिए उसको क्लिक करिएगा.
स्लाइड शो.
हाँ.
ओके सर.
हुआ नहीं है कि वो फुल स्क्रीन आएगा तो लोगों को बेटर दिखता है, बाकी कोई दिक्कत नहीं है. ओके रिक्वेस्ट आ रहे हैं उसके हिसाब से.
अच्छा. ये आ गया?
नहीं है सर, वो स्लाइड शो क्लिक आपको दिख रहा है पूरा.
I have a lot to learn, sir, especially about these technical things.
नहीं है, सॉरी टू डिस्टर्ब यू, बट आपको वो दिख रहा है, आपको पूरा स्क्रीन दिख रहा है वहाँ पे?
हाँ, बिल्कुल सर.
ठीक है, चलिए.
I think there is some issue with my computer. Okay. The moment my computer would be connected, this whole thing will come there.
Okay.
Or let me see if I can do it from my telephone also.
Yeah. नहीं, फोन से नहीं आएगा, ठीक है, आप कर लीजिए, कंप्यूटर होगा तब कनेक्ट कर.
हाँ, I think, don't know. Sir, kindly bear with me, sir. Okay.
Yeah, no problem. हाँ. Please continue. क्योंकि आपका दोनों लॉगिन दिख रहा है, आपके यहाँ से खाली रिले नहीं है.
सर, मेरे यहाँ से इशू है.
ठीक है.
Now, sir, another rule is the golden rule of interpretation. So it is a form of statutory interpretation that allows the judge to depart from a word of normal meaning in order to avoid an absurd result. Now, the golden rule here, the interference of the judge starts, and that is actually very important also, because if there is a form of a statutory interpretation that allows the judge to depart from a word's normal meaning, suppose if the normal meaning is leading to a situation where the whole meaning has become absurd, then that absurdity has to be avoided. Cannot be taken into play. So I think my screen share has gone now.
Yeah, it is out now.
Yes, I think because there is this network issue.
ठीक है sir, you continue. जब आएगा तब करेंगे.
Yes. So this golden rule is actually a compromise between the several rule between the strict rule of interpretation and the rule of mischief. Now, rule of mischief, I'll come to that after this slide. So the golden rule of interpretation, as the very word gold means, that to interpret a law in a manner that any absurdity is avoided, any what is happening? So can you hear me, Mr. Vijay?
Yes, sir, we can hear you.
Okay. So now we will come to the mischief rule of interpretation. The very word mischief in this shows that when a law is made to take care of a particular mischief, then the interpretation of the law must be done in a manner that the same mischief cannot be allowed to be repeated by any method whatsoever. The interpretation has to be done if there has to be some deviation from the literal interpretation, then that deviation has to be made. But every effort has to be made to ensure that the mischief is not repeated, the defect is totally cured. So we have to see that what was that mischief, what was that defect to get rid of which this law has come, what was the remedy which has been provided by the parliament, and what was the true purpose of that remedy. Then the next rule is the rule of reasonable construction. This rule stresses upon the intention of the legislature to bring up the statute and sensible and not the prima facie meaning of the statute. So suppose if the prima facie, the meaning or the interpretation of the statute leads to a situation which is unreasonable, then that has to be avoided. Law cannot be unreasonable. The law has to be reasonable. And if the law is unreasonable, then it has to be struck down to that extent of the unreasonableness. Now there are another situation where there are two or more statutes which are operating in a same sphere. On a same subject, there are two or other law or two or other statutes in operation. So here the role of the harmonious construction comes into play. That if the two laws have to be interpreted, then it must be interpreted in a manner that it does not make redundant any one of them or both of them. If there is a conflict between the two laws, or there is a conflict between the part of the law, then the constructions need to be harmonious. Here, as we are aware that the Constitution has provided for the central list, state list, concurrent list. So if there is a dispute between the state law and the central law, it is well known fact that the central law will prevail. If there is a dispute between the law made by state and government on the issues of the concurrent list, then the law made by the central law will central government that will prevail. So the basic law is the law of construction. I think this share is. Let me again share the screen, sir. So that is the rule of the harmonious construction.
उसमें स्लाइड शो चालू कर दीजिए एक बार वो नीचे का.
Okay, sir.
हाँ, इसको क्लिक कर दीजिए.
Yes, sir.
Yes, sir. Now it's good. Thank you.
Okay. So the duty cast upon the court is to construe the contradictory provision to harmonize them. If we will see, many a times the Act itself provides that this particular provision of law will prevail over other provision. We will come to the subsequently that there are non-obstante clause where the legislature itself intended that this particular provision of law will be prevailing over the other provisions of the law. Now, at the time of the harmonious construction, suppose it has become impossible to reconcile the two law. What has to be done in that scenario? Then the court must interpret the law in such a way so that the effect is given to both the provision as much as possible. And if there is the harmonious construction is not actually possible in any method, then then one part of the law which are the prior time in the nature, or which is if there is a dispute between the central law and the state law, then the central law will prevail. If there is a dispute between the older law and the new law will prevail. So these are the tools of interpretations and these are the methods of the interpretation. Then how it has to be done. Now, next comes the rule of the beneficial construction. We have seen that there are several beneficial statutes, like the entire labor statutes, the taxation statutes is thought to be for the benefit of the taxpayers. How far is that actually done? That is entirely a different matter of debate and discussion. So suppose if there is a beneficial law, if there is a labor law, then the rule of interpretation says that if a particular law has been enacted for a benefit of a certain section of the society, then its interpretation has to be done in a manner which will give benefit of that particular section of the society. Like one example is given that in one case the tribunal awarded more number of paid leave to the worker than stated in section 79(1) of the Factories Act. This has been challenged and the Supreme Court held that the enactment being a welfare legislation for the worker, so the interpretation and the construction has to be done in such a manner that it gives more and more a benefit in the favor of the workers. Now there is a exceptional construction. So it stands for the elimination of a statute and word in a statute which defeats the real objective of the statute or make no sense. Now, if there is a rule of exceptional construction. Now, as I said earlier, there may be a situation where the interpretation has become actually absurd and no other method is even by adopting the harmonious construction or the beneficial construction or mischief rule. So by adopting all other such methods, even by that, no proper meaning is coming out of the act. That particular law has been drafted in such a bad manner that by adopting all the principles, it has not been done. Then in such exceptional circumstances, the court, they take resort to elimination of those words. And the whole purpose is that the law has to be interpreted and it need not be an absurd interpretation. It has to be for the benefit of the intended people. So whatever best that can be done has to be done. If nothing happens or if nothing is helping, then it will go to the extent of eliminating the word. Now there is another rule of interpretation, and that is of the adjustum generis. This is one principle which is used maximum in the taxation statute. Like many a times. So this rule provides that where the word of a specific meaning are followed by general words, then the general words will be construed as being limited to the person or thing in the same general kind or class as those enumerated by specific word. Suppose the first word is that this principle will be applicable on motor vehicles. And then it is said truck, bus, tractor, car. So, or truck, bus, tractor, car, motor vehicles or other motor vehicles. Now here if we say that a particular class of the vehicles are given, so the interpretation of those examples or those general words has to be done and has to be limited to the specific word which was the first word. It cannot go beyond that. Suppose the word is the specific word is cooking oil. So after the cooking oil, it is the coconut oil, mustard oil, and other things. So those has to be interpreted strictly in the specific word being provided at the starting of this word. So the rule of adjustum generis is to limit the implication and impact of the general words. So this rule applies when the statute contains an enumeration of a specific word. The subject of enumeration constitutes a class of category. So that specific word that must contain a class of category. That class or category is not exhausted by enumeration. The general item that are following an enumeration, and there is no indication of a different legislative intent. So if all those 5 criteria are fulfilled, then this rule of adjustum generis are implemented. The Kerala High Court in the case, it said that the construing the word body of individual occurring in section 2 clause 31 of the Income Tax Act alongside the word association of persons, the word body of individual have to be understood in the same background, context and meaning given to the word association of persons. Now there is a Latin phrase nocitur or socius. It means it is known from the associates. So the question meaning of the word or a doubtful word can be derived from the association with the other word within the context of the phrase. So if there's a word in a list within a statute and that particular word has more meaning than one, then in that scenario we'll have to see that what is the associated word. And the interpretation has to be done in context of the associated word. Then there's a Queen's Bench division, Queen's Bench a judgment in this, that the case involved a state which stated that the explosive taken into mind must be in a case or a canister. The defendant used a cloth bag. The court had to consider whether the cloth bag can be within the definition. The court held that the cloth bag would not come under the definition because the intention in using the word case or canister was referring to something as same strength as canister. So the canister being a hard substance, so the strength of a canister. So if there is the case has to be something which is strong, which is hard. So a cloth case cannot be interpreted in the same manner. So that is why the associated word are another tool for the interpretation of a particular word. Then there's another Latin phrase that is expressio unius est exclusio altruis. It means if there is one word has been used, it means that it has been used to the exclusion of all others. Said it is called negative implication rules. Suppose, for example, only one word is given. Then it will be taken that if the legislature intended more things to be included in this, then they would have used or they would have taken named those things also. So if there is only one word is given, then it is intended that it has not to be applied more than this. It assumes that the legislature has intentionally specified on a set of criteria as opposed to an example or other criteria. This rule is indicated as it includes or such as. The courts have held that this maxim should be disregarded where an extended interpretation of the statute will lead to beneficial result, as I have said you earlier. Beneficial legislation has an overriding effect on other principles of interpretation. If the law is interpreted in a manner by a court so that it can give more and more benefit to the intended people, then it will override the other rules of interpretation. The next principle is the contemporanea expositio est optima et fortissiana in lege. You don't need to remember these phrases. When we don't remember many of these phrases, I think the British judges, they have some fetish for all these Latin terms. So we can use the normal English and the normal word that we are understanding. It means that the contemporaneous exposition is the best and strongest in law. It means that the publicly given contemporary or long professional usages is presumed to be the true one, even where the language has etymologically or popularly a different meaning. So if a particular word is understood in a particular trade or in a particular trade practice in a certain manner, then if that word is used in a law pertaining to that very industry or that very area, its interpretation has to be guided and decided by its trade uses. Even though its etymological meaning, it is history, or it is another meaning, it may be different. But if in a particular trade practice, if the word has a certain meaning, it has to be interpreted in that very meaning and no other. There are certain presumptions, as I have said earlier also. The first presumption is that the statute, that the parliament, the assembly, at the time of the making of the law, it was aware of all other law which were in existence. It was also aware of every word, every comma, full stop that it is using for a purpose. There is another assumption that the statute is not a retrospective effect unless it is said so in the statute. Otherwise, the law will come into force from the date it has been. In fact, in the very top of the law, it is mostly given that when that law will come into force. Sometimes the law comes into force instantly. Sometimes the law is deferred, and it is said to be that this law will come into force as and when notified by the government of India or the particular state. So, if a legislature intend a law to be retrospective, it will say so. If it has not said, and if the situation has such arisen that that particular law is capable of more than one interpretation, then the matter has to be taken to the court, and the court will decide whether it was a prospective operation of the law or the retrospective operation. The second presumption is that the law does not alter the common law. If it is capable of two interpretation, one involving alteration of the existing law and other is not, then that interpretation will have to be accepted, which does not involve the alteration of the existing law and the alteration of the common law. If a person is deprived of his property for nationalization, he should be compensated. This is a presumption. It cannot be a situation that I'm deprived of my property and the interpretation of the law is such that I cannot be compensated. Then there are fundamental rules of law. What are those fundamental rules of law? The one is a person cannot be condemned unheard. A person cannot be judged in his own cause. The person cannot be condemned twice for the same cause. So these are the presumptions that the person shall be given a reasonable opportunity. Even if the reasonable opportunity principle is not provided in the law, then it will be read into the law. This has been done in electricity law. This has been done in insolvency bankruptcy code. This has been done everywhere. So even if no method of issuing notice to other side is provided in the law, it has to be read in the law. Why? Because that is the basis of that is the fundamental of the law. That is the fundamental of the justice also. A statute is not intended to deprive a person of his liberty. The interpretation must take into consideration that it cannot be interpreted in a way that it deprives a person of his life and liberty. A statute cannot impose criminal liability without proof of guilty intention. Strict liabilities are imposed. There can be a situation like in the cases of the dangerous driving. Now, if there is a dangerous driving, even though I had no intention of that, so those are different things. There is another assumption that one statute, it will not repeal other statute, and every effort has to be made as far as possible to harmoniously construct both the laws. Then there are other tools of interpretations. See, why I am going into the detail of all these tools? Because all these tools, they must be imbibed in every professional in their day-to-day interpretation and understanding of the law. Because based upon these interpretation only that we will be in a position to advise our client, to advise or to interpret the law, and to put our case before the court of law. So, stare decisis. Now this says that to give a law a finality and to maintain consistency, the principle of stare decisis is applied. It is true that a law is a very dynamic concept. It keeps on changing every day. But at the same time, it is also and equally true that a dispute has to be put at rest. A finality has to be given to an interpretation. A finality has to be given to a law. Now, interpretation of a provision which was rendered long back and which has been accepted, which has been acted upon for a very long period of time, that interpretation must not be easily done merely because one other interpretation is also possible. While reconsidering and while trying to go for other interpretation of a decision rendered long time back, the court cannot ignore the harm that it is likely to cause by unsettling the settled position of law. Interpretation given to a provision by several high court without dissent and uniformly followed, several transactions have already entered based upon that very interpretation of the law and the said exposition of the law. There the doctrine of stare decisis must be applied, or it will lead to a very chaotic situation. It will open a Pandora box of the litigation. It will usher into an era of uncertainty. Now we must have seen that there are several statutes or the several sections which starts with the phrase, notwithstanding any other law for the time being in force. This is called a non-obstante clause. Now this non-obstante clause is showing the intention of the legislature that he wanted this particular provision to override all other provision of the law. MSME, that Micro, Small and Medium Enterprises Act, Section 15 starts with the clause, notwithstanding any other agreement. So the intention of the legislature, they wanted that the law, that particular Section 15 of the MSME Act should override whatever agreement the MSME have had with the other industry or with the other bodies. The intention was to override every other law. So here the interpretation of the law would be done that that particular provision of law would be constructed in a manner that it would override all other law. There is another aspect, as I have said earlier also, that if the law which has been implemented in later in time, it will be interpreted over the law which was prior in time, unless there is a non-obstante clause in the earlier laws. And so it conveys that in spite of the provision of the act mentioned in non-obstante clause, the enactment following such expression shall have full operation. It is used to override the mentioned law provision in specified circumstances. Now, what is the main basis of the taxation law, and what should be the concept for the interpretation? there is a very famous quote by one Mr. Cardozo. He said that you may say that there is no assurance that judges will interpret the mores of their day more wisely and truly than any other men. I am not disposed to deny this, but in my view, it is quite besides the point. The point is rather this: the power of interpretation must be lodged somewhere, and the custom of the Constitution has lodged it in the judges. I will once again repeat the words of Mr. Tolani. He has said that this construction is the soul of the body. Now, this soul of the body is the most important part. That is why it has been put in the hands of the judges to make this interpretation. It is not said that the judges are somebody who have come down from the sky or something like that. But it is expected, and it is the confidence has been put into them by the Constitution, by the law, by the society, that by their experience, by their knowledge, by their wisdom, by their personality, they are competent to do this work of interpretation. And by far we have seen the judges of the country have fully discharged this duty and this confidence which has been entrusted upon them. So now coming back to our subject. Article 265 of the Constitution, it has mandated that no tax shall be levied or collected except by the authority of the law. It provides that not only levy but also collection of the tax that must be under the express authority of the law. The tax proposed to be levied, it must be within the legislative competence of the legislature imposing the tax. Now, what is this legislative competence? If the state legislature has made some law, then it has to show that this particular law is derived from the particular subject which is there either in the state list or it is there in the concurrent list. Therefore, when it made this law, then the particular parliament or the statute or the assembly, they had the competence to make law on that particular subject, because if it is not that so, then that particular law has to be struck down by the court for being without proper legislative competence. Then the validity of the law is to be determined with the reference to the competence of the legislature at that particular time. I suppose the state had this competence to make the law, but by way of some amendment in the Constitution, that a situation has been changed. So it cannot make the law if it is no longer at that particular time within his competence. Or suppose the competence has been provided subsequently. Even that will not cure the defect that at the time when the law was made, the legislature did not have the competence. Next part is that the law must be validly enacted. The Constitution has provided a very strict method of enacting a law. If it is a money bill, it will be presented before the Lok Sabha. If it is any other bill, it may be presented first before Lok Sabha or before the Raj Sabha. It has to be discussed, then there will be voting. So a very elaborate method has been provided. So if that method has not been followed strictly, then the law will not be said to be a valid law and the court is competent to strike down the law. Next aspect is that the law must not be a colorable use or a fraud upon the legislative power to tax. So this vice of colorable exercise of legislation has to be avoided, because that is one of the major ground of striking a law or of striking a particular portion of that law. The tax must not violate the condition laid down in the Constitution and must not also contravene the specific provision of the Constitution. no tax can be imposed by any bylaws, rule, regulation, unless the statute under which the subordinate legislation is made specifically authorizes the imposition, and the authorization must be expressed, not implied. So the judiciary has been very conscious, has been very alert in protecting the interest of the taxpayers, have jealously guarded the interest of the taxpayers, that no undue tax is imposed which is not as per the competence of the executive or the competence of the legislature. The procedure prescribed by the statute must be followed. It is saying that if it is not done as per the procedure prescribed by the law, the entire law is illegal. So tax is a compulsorily extraction made under an enactment. The word tax in its wider sense that it includes all money raised by taxation, including taxes levied by the union or the state legislature, the tax including any impost general. So these are the definition of the taxes. I need not go much into that. But while using the principle of interpretation, we have to see that the test of the vice of discrimination in a taxing law are less rigorous as that of the other social enactment. It is well established that the legislature is promulgated to exercise an extremely wide discretion in classifying for tax purpose, so long as it refrain from clear and hostile discrimination against particular person or classes. So this discrimination has not that very important role to play in this. So the fundamental rule of construction is the same for all statute, whether there is a fiscal, penal, and otherwise. The underlying principle is that the meaning and intention of a statute must be collected from the plain and unambiguous expression used therein. Am I audible? Hello?
Yes, sir. Yes.
Yes, sir.
Okay. Actually, I'm disconnected from one place. That's why I asked. So as I said that the strict interpretation, that is be the mischief rule of interpretation, golden rule of interpretation, the same rule have to be implemented for the interpreting the taxation law also. That the taxing statute should always be given literal and strict interpretation is something which makes the interpretation of taxation law different from other law. Including any other word into the law has to be discouraged. Every word has to be interpreted the way it is written, strict interpretation and literal interpretation. The taxing enactment should be strictly construed and the right to tax should be clearly established. Unless there is the right to tax, it cannot be read into that. It is a well-established rule that the subject is not to be taxed unless the word of taxing statute unambiguously impose the tax on him. Therefore, wherever there is an ambiguity, then the taxpayer has to be benefited. That very interpretation has to be taken, which is for the benefit of the taxpayer. The statute should clearly and unambiguously convey the three companion of tax law: the subject of the tax, the person who is liable to pay the tax, and the rate at which the tax is to be paid. Yes. It should be. So if there is an ambiguity regarding any of these ingredients in a taxation statute, then there is no tax in law. Here I mean to say that if they, as I said, the strict interpretation of the taxation of the law, it assumes that in case of an ambiguity, the particular statute has to be struck down. It has to be read in a method. It is helping the taxpayers. Now, if you see that the cases under the Taxing Act always resolve themselves to a question whether or not the word of the Act have reached the alleged subject of the taxation. In construing such Act, we have no governing principle of the Act to look at. The court has to simply see whether the duty or tax claimed is that which the legislature has enacted. Now, the Supreme Court has said in a judgment of the Commissioner of Income Tax versus Provident Investment Company, in construing fiscal statute and in determining the liability of a subject to tax, one must have regard to the strict letter of the law and true legal position arising out of the transaction in the question. Now, in another judgment of A.V. Fernandez versus State of Kerala, the Constitution Bench of the Supreme Court observed that it is no doubt true that in construing fiscal statute and in determining the liability of the subject to tax, one must have regard to strict letter of law and not merely to the spirit of the statute or the substance of the law. If the revenue satisfies the court that the case falls strictly within the provision of the law, the subject can be taxed. On the other hand, if the case is not covered within the four corners of the provisions of taxing statute, no tax can be imposed by inference or by analogy, or by trying to probe into the intention of the legislature and by considering what was the substance of the matter. So therefore, the court cannot say that the intention of the legislature was to impose a tax. So even though the words are not there, we will interpret it in a manner so that the tax can be imposed. No, it cannot be done in that manner. So a fiscal statute, while interpreting the fiscal statute, the court cannot proceed to make good of deficiency if there is any. If there is, if some word is missing, or if some a procedure is missing, if some step is missing, so that is a serious deficiency. That is a serious lacuna. That lacuna cannot be filled by the court by adopting any method of interpretation as far as the taxing law is concerned. If there are two views possible, the one view which is favorable to the SSE in a matter of taxation, that has to be preferred. The SSE should be given the benefit of doubt, and the opinion which is in favor should be given effect. An exemption clause in a taxing statute must be, as far as possible, liberally construed in favor of the SSE, provided no violence is done to the language used. Exemption from taxes that should be given full scope and amplitude and should not be whittled down by importing limitations not inserted by the legislature. However, the Supreme Court has also held that the exemption is the creation of the statute and it must be construed strictly and it should be extended. Now, again, it comes down to the theory of two interpretation. The one favorable to the taxpayer to be, that interpretation has to be adopted. While dealing with the taxing provision, the principle of strict interpretation is adopted is a universal principle. The court shall not interpret the statutory provision in a manner which would create an additional fiscal burden on a person. It would never be done by invoking a provision of another act which are not attracted. It is also tried that the same thing is once again reiterated that in case of two principles, the one for the benefit of the SSE has to be taken. So this the judiciary in our country has adopted this method of interpretation. This is a constantly ongoing process, a process in which both the part of the stakeholder, be it the lawyer or the chartered accountants, or the other side, that being the judges or the interpreting officers. This process goes on, and it is these interpretation and the change in the interpretation which actually lead to the development of the law. So I feel and that by this speech, I have been able to explain to you that what are those methods, what are those tools which must be in your kitty to understand the law, to appreciate the law, and to adopt the problem that has been posed to you by your client in the for the particular relevant law. And with those words, I express my thanks to everybody for listening me out so patiently. Thank you very much. Mr.
Thank
Vijay.
you, Rajiv. Thank you, Rajiv.
Yes, sir. Yes,
it
sir.
was indeed a pleasure to hear you, and you justified the topic in your very lucid language, and brief and comprehensively you gave justice to the topic. Friends, now we will move on to our third session, that is a question answer session. Though there are not many questions, but I'll take up those who are visible, which are visible on chat. Rajivji, one question is from, just a minute. Yeah, one question is from CA Pankaj Agarwal ji. He's from Lucknow. He has asked a very basic question to speak something on retrospective operations also.
Retroactive operations.
Retroactive operations also.
Hello.
Yes, sir. You got the question, sir.
Hello.
हाँ राजीव जी बोलिए. I think he has a issue. Rajiv ji, can you hear us, Rajiv ji? राजीव जी सुन पा रहे हैं हमारी आवाज?
हेलो.
नहीं जा रही शायद.
राजीव, there is some technical glitch.
राजीव जी आवाज आ रही है हमारी आपके पास?
हेलो.
नहीं जा रही. चलिए ठीक है.
Presently we are RP sir also with us. Can he put some light on this query?
Yeah. RP sir, please अपना unmute करिए. And please start your video. Sorry. Yeah.
Hello.
Yeah, Tolani sir, please.
Yeah.
Tolani sir, there was one simple question from our viewer.
Yes, please.
Is CA Pankaj Agarwal from Lucknow. He wanted to hear from you. His request is to speak something on retroactive operations. Can we put some light on it?
Yeah. So retroactive operation is a very long subject, and recently means about 3 years back, Honorable Supreme Court with a 5-judge bench, I'm forgetting the name, I'll let you know. They have almost given a complete thesis on what can be done retroactively and what can be done prospectively. Basically, procedural laws and the laws which do not fasten any legal liability, pecuniary, penal, quasi-penal, cannot be enacted retrospectively by way of the Constitution, that the taxes shall be imposed only when they are legally and correctly due. I will tell you just now, I'm just processing my mind. This judgment gives, there was some excise law on which the government of India issued a retrospective legislation. Now, in this context, the Vodafone tax case is the worst example. Now, what happened? The issue went right up to Supreme Court, and Mr. Salve argued for days together. Supreme Court ruled in the favor of the assessee, that is Vodafone. That was a tax of capital gains on some assets which are situated in foreign jurisdiction and they had no presence in India. Okay. Now, Government of India brought up an amendment that this is applicable retrospectively from 1964. In my practice and my experience, this was the longest possible retrospective operation. What I mean to say, to amend taxation laws retrospectively is a very bad idea, and in a democratic setup where there is a clear rule of law, where there are clear defined power of executive and judiciary, laws are a sort of unwritten punishment to the subjects. And I think it is, yes, now I remember. This is Vatika Township case. It is a 5-year judgment, and Justice Lola, R.M. Lola, he has written the order. He can go through that. It gives a complete picture of what government can do for retrospective legislation and what it cannot. And being an order of the Constitution bench, it has full precedent value. So, Mr. Pankaj Agarwal, I would rather request you, it's quite a long judgment, and you are interested in this very crucial topic, you please read that judgment. It will give you answer to all your issues. I think it's okay.
Thank you, sir.
It's a big topic, I tell you.
Yeah. Proceed, sir.
ठीक है संजय जी दूसरा क्वेश्चन एक अभी आया है
Mr.
Okay, thank you very much for your kind answer, sir. There is one other question from Retd Dwivedi, ma'am. She has asked, have the rules of interpretation regarding tax laws changed with changes as well as the revolution of the act over the years, or have the same remained constant?
See, the non-statutory rule of interpretation are basically based on judicial precedent. So as and when new judgments come, they add some flavor. But fundamentally what remains is literal interpretation, purposive interpretation, then reasonable interpretation, harmonious interpretation, adjustum generis, exceptional rules, they deal with and, or, shall, may, will. So these are the broad areas. This is not a codified law. But as soon as some good judgment comes, it adds to the overall literature available on non-statutory interpretation. Whereas statutory interpretation, that means definition clauses, explanation clauses, there are any number. So it's a dynamic thing. It will keep on evolving. Even Madam Ritu can argue some good case and she can come up with a very good interpretation. I will give you one example. I gave a judgment in Bombay in which a lady sold a flat on Hanging Garden in those days. She had 2 daughters. She purchased two apartments against the sale of her house in the 2 separate daughters in 2 separate buildings. Now they wanted to claim deduction of capital gains, saying that the house means more than one house. I ruled against it. I said no. The interpretation is very simple, that a house against a house is exempt. But ultimately, Bombay High Court did not agree with me. And they said, yes, a house can mean 2 flats. So now it was a dynamic interpretation. And now, as it stands, if you had 2 adjoining flats, it is considered as one house. So you see, with changing times, with new, it's fact-based. You may come up with a new fact. So a new set of interpretation may evolve. So it is a ever-changing, dynamic, progressive line of law. It's a very good question. The doors are not always closed. They go on opening new windows. So you must always look into the new cases which come on the issue of interpretation. That's my reply.
Thank you, sir. It was indeed a good pleasure for us, and your experience is helping us very well. And you explained both the queries with examples and landmark decisions. Friends, now we will move on. There are no many other questions. Now we'll move on to our next session, next section. I'll hand over the charge of the session to our very own Vijay Keval Ramani ji to extend a word of thanks for today's dignitaries. Over to you, Vijay sir.
Before that, I would request Tolani sir to give his closing comments, please.
Yeah, so ladies and gentlemen, it was a very good experience, and I think the advent of Corona or COVID-19, see, every coin has two faces. So let us look at the brighter side of it. Otherwise, for you organizers to arrange this type of intellectual debate would have been a mammoth task, asking people to come over Bombay or Delhi, make hotel arrangements and everything, and then a lot of time goes in pleasantries. Here, we could wrap up the program within 2 hours with a lot of intellectual inputs. So, I think, and I saw your all organizations are very experienced organizations, AIFTP, and so many zonal and regional organizations. We can form a better platform, and we can keep on extending the ideas without much formalities, which will add to our knowledge, our experience, and there will be sharing of mind, meeting of mind, and it is a new chapter, dawn of a new era in intellectual wisdom, in spreading the more legal awareness. So I thank you all and all the participants, Mr. Rajiv Dwivedi, Mr. Nikam, and all the queries for being on this webinar, and I expect all of you will join, all of us will join in the next webinar as well. All my best wishes. You have done a very good job, and you deserve all the encomiums for your very good effort. Thank you very much. Have a nice day.
Thank you, Tolani sir. राजीव जी, can you hear us now? राजीव जी, आवाज आ रही है?
Webinar.
Yeah, ठीक है. चलिए. So friends, going to the pleasant task of giving vote of thanks. It gives me great pleasure to thank all of you. Initially, I would like to thank Tolani sir for having accepted our request and guiding us on the important topic of interpretation of statutes.
Office.
And definitely Rajiv ji for having consented to my request and taking out time in spite of his busy schedule in the Supreme Court and guided us on the program. Friends, before ending, now I would like to give my final vote of thanks, because this being the 34th seminar and most probably the last, because we are not sure what the government would be deciding. We also created a poll where we have been requested by all the participants and said that we should continue the series of webinars, but definitely that would all depend on that would all depend on the government increasing the lockdown or no. If it increases, we have a committee meeting of our associations tomorrow, so we'll decide tomorrow if it is possible. We will continue. Otherwise, we have planned that every Saturday 11:30 to 1:30 we will have a webinar, we'll continue the series, but maybe not 3 in a week, but every Saturday we will be having meeting 11:30 to 1:30. I would like to personally thank all the participating associations: Tax Friends, Tax Practitioner Association Thane, Josh Professional Foundation, Legal Relief Society Kolkata, Bhiwandi Tax Practitioner Association, Income Tax Bar Association Prayagraj, and Income Tax Bar Association Varanasi, to be with me and us always. And especially I would like to name our core committee members: Atamji Tekchanani, Haresh Chugani, Bharat Sachdev, Sanjay Nikam, Girish Rathi, Sanjay Kumar from Prayagraj, Arvindji Mishra, who was always present, Mansukh Waghela, OP Shukla and Asim Jafar and Jamna Shukla ji from Varanasi Association, Rakesh Agarwal and Virendra Popat from Bhiwandi, and Kamlesh Sabu and Vinod Tikmani from Josh Professional Foundations. Friends, without their support, it would have not been possible for me to conduct all these seminars. So thank you, friends. Looking forward to meet you again, hopefully We'll meet next week. And yes, we are also planning one big meeting. So please stay tuned. We will announce the program. Thank you. Thank you very much.
Thank you everyone. Thank you, Vijay. Thanks a lot.
Everyone for participating.
Yeah, now open for all.
कैसे हैं?
Yeah. मनोज भाई आइए ऑनलाइन, क्या हो गया?
How are you, Srivastav sir?
Good sir, how are you?
Thank you for your WhatsApp.
सर आपका भी वो बढ़िया है, आपने अच्छा भेजा वो.
दादा तोलानी साहब अनम्यूट क्या होता गाला सको?
तोलानी साहब है चले गए?
है
है